Ready? Start. Against the judgment of Trial Court Civil Appeal Number 23 was preferred, which was heard and allowed by the judgment dated 21st November 2015 by Additional District Judge Court Number 5 Balia. In its judgment, the First Appellate Court had held that in present case sale deed in question had been properly executed, after which the mutation of name of defendant was carried out disputed agricultural property. The First Appellate Court had held that in present contract of sale and execution of registered sale deed in question, time of payment of remaining sale consideration was not a sense of the contract for transferring ownership of disputed property, which was transferred by sale deed in question from plaintiff to defendant. So the said property executed sale deed cannot be cancelled because it was neither voidable nor void, but for default in performing his promise of payment of remaining consideration, plaintiff is entitled to recover remaining consideration damages from the defendant. Aggrieved by the judgment of First Appellate Court, present second appeal was preferred by plaintiff of original suit. Learned counsel for the appellant contended that since it was agreed between the parties and in sale deed dated 20th August 2004 in question, that the time for payment remaining consideration of rupees 1,64,000 is a sense of contract for sale, and since said amount was not paid by defendant, therefore the sale deed in question is liable to be cancelled, and judgment of trial court in this regard is correct and proper, which should be upheld. Learned counsel for the respondent contended that payment of remaining consideration of rupees 1,64,000 was not a sense of contract of sale. Had this been a sense of contract for sale, then plaintiff would not have given consent before revenue court at the time of mutation of name of defendant, which was carried out after 1 month of execution of sale deed. He contended that defendant was ready and willing to pay remaining rupees 1,64,000 of unpaid consideration, but plaintiff and his brother colluded, and thereafter the plaintiff's brother had filed another suit for permanent injunction about the property sold by plaintiff, in which stay order had been passed by the concerned court. Therefore, the defendant was unable to pay remaining consideration in spite of his willingness. He further contended that at the best plaintiff can get payment of consideration of rupees 1,64,000. He further contended that in fact this amount was deposited in court by defendant respondent. Therefore, there is no error in judgment of First Appellate Court, and this appeal should be dismissed in lamine. Admittedly, the parties had entered into a contract for sale, and in compliance of which registered sale deed in question was executed by plaintiff in favor of defendant. It is also admitted case that part of the consideration had been paid at the time of execution of sale deed in question, and for remaining part of sale consideration It was written in sale deed that it will be paid within 1 month by defendant to plaintiff. It is also admitted that remaining consideration was not paid by the defendant till the institution of the suit stopped. You are skipping after watching the video. Please like the video and subscribe our channel so that we can get inspiration or courage to make new videos so that we can bring new content for you guys. Thank you so much for watching our videos.